Deeds. It is a document which is in writing on paper, signed, sealed, and delivered. The essence of a deed is for a transaction containing a deed to create a binding obligation and give effect to the transfer of an interest or right in property, or confirm some act whereby an interest or right in property has already passed. There are three types of deeds: 1. A deed poll, 2. The indenture, and 3. A deed supplementary. A deed poll is executed by only one person, whereas a deed indenture is executed by more than one person. A supplementary deed is used to vary, add, or remove a clause with the consent of the parties. However, note that it must recite the deed intends to vary or amend. A deed may be employed in effecting the conveyance of an interest or right or property in real estate, in creating an obligation binding on the person, or in confirming an act where an interest or property has already been transferred. Deeds are required for certain power of attorney or where a statute mandates it. A deed is also required for a surrender of interest. However, note that deeds are not required where assent or vesting orders are employed or where there is a surrender by operation of law. A short-term lease also does not require a deed. Transactions requiring a deed now to be valid include: 1. Gift of land, 2. Transfer of legal interest in land, 3. Power of attorney vesting power in an attorney to execute a deed, CRB and FAR, Powell and London Provincial Bank, 4. Lease for a term exceeding 3 years, section 79 sub 1 and 2 of the PCL, 5. Vesting declaration where new trustees are appointed, 6. Voluntary surrender, this is where a lesser estate is given up to merge with a greater estate in land. 7. Rectification of deed, i.e. deed supplementary. 8. Creation of a legal mortgage in state under the Conveyancing Act and the Property and Conveyancing Law. 9. Discharge of a legal mortgage where created by subdemise or assignment in state subject to the Conveyancing Act. 10. Where statutorily required, see Section 3 Real Property Act 1845, Section 77 Sub 1 Property and Conveyancing Law, and Section 4 of the Statutes of Fraud Act 1677. Transactions which do not require a deed for validity include: 1. Assent. An assent, also described as a vesting assent, is the instrument by which the personal representatives of a deceased person convey land to the beneficiary entitled to it. 2. Surrender by operation of law. Surrender by operation of law usually take effect by implication, for example, where a lessee accepts a new lease incompatible with his existing lease. 3. Lease or tenancy for a term not exceeding 3 years. See Renite, Hand and Hall. In Renite, the lease was for a period less than 3 years with the right to remain for a further 3 years. Therefore, it was only demised for a term less than 3 years with an option to renew. As such, it was not required to be under seal. 4. Receipt. These are not required by law to be under seal. For example, a receipt endorsed on a mortgage serves as sufficient discharge of the mortgage. 5. Vesting orders. A vesting order is an order made by a court to create or transfer a legal estate in land. For example, where an equitable mortgagee exercises power of sale, the court may make an order vesting the land in the purchaser. 5. Conveyancing taking effect by operation of law. Property vests by operation of law in several ways, such as: a. Admission of a will to probate, b. Grant of letters of administration, c. Appointment of trustees in bankruptcy. 7. Certain disclaimers. Section 56 of the Bankruptcy Act provides that a trustee in bankruptcy can disclaim onerous property forming part of the bankruptcy estate, e.g. land burdened with onerous covenants. Also, where a beneficiary refuses a gift under a will without doing so in writing. 8. Transactions covered by the rule in Walsh and Lonsdale. The rule is that an instrument which is void as a conveyance because it is not a deed may still operate in equity as an agreement for a conveyance. Essential elements of a deed. Signing. As a rule of evidence, every document must be signed to be admissible in court. Section 83 and 94 of the Evidence Act 2011. A person cannot incur an obligation under a document unless he has signed it. See Section 97 Property and Conveyancing Law, Faro Body Company Limited and OCG. If an illiterate or blind person is to sign a document, an illiterate or blind person's jurat must be inserted and attested to by a magistrate, notary public, or a legal practitioner. See Akingbade and Olainka, Section 91 sub 4 of the Evidence Act 2011. If a document is to be signed by a company, the company should always affix its common seal. See Section 71 and 74 of the Companies and Allied Matters Act, Section 98 Property and Conveyancing Law. Sealing. Sealing is not necessary for an individual as that is implied. Section 159 of the Evidence Act 2011. In First National Security and Jones, a mortgage deed was signed by the mortgagor. The signature was across a printed circular at the end of the deed, and in that circular were printed the letters LS standing for the Latin phrase locus sigilli, meaning place of the seal. The mortgage was held to be validly executed. She also stormed Deal and Ball and Boarding, Carlin Nigeria Limited and University of Jos. Note that for companies executing documents, documents must be sealed. Section 71 and 74 Companies and Allied Matters Act, Containers Nigeria Limited and Glasgow Limited. Delivery. The document must be delivered. Anambra State Housing Corporation and Imekwe. Delivery is an act done to evince an intention to be bound and occurs when interest passes. See Jegede and Citycorp Nigeria Limited. Sometimes delivery takes place subject to a condition which may be expressed or by implication, and when this happens, it is called delivery in escrow. See Dalfarm Nigeria Limited and Okako International Limited. Delivery may be absolute or conditional. Where a deed is delivered in escrow, it is still binding on the parties. A party cannot back out of a deed delivered in escrow before the time limited for the condition to be fulfilled. A deed takes effect on the date of delivery, even where it is in escrow and there exist subsisting conditions. Terrapin and IRC, Beasley and Hallwood. The doctrine of relating back will only operate when the condition is fulfilled, and the date of signing the deed will be the effective deed and not the date the condition was fulfilled. Any act of the party showing that the deed is intended to be binding upon him is sufficient evidence of delivery. Where a vendor executes a conveyance in advance of completion and delivers it to his solicitor, executes the deed subject to the implied condition that it is not to become effective until the purchaser has paid the purchase price to the vendor's solicitor. Mere physical handing over or delivery without an intention to be bound does not amount to delivery for this purpose. See Awojugbagbe and Chinukwe. Attestation. This is the witnessing of the deed. At common law, attestation is not necessary to give validity to a deed. It is however prudent to add the clause to the deed as it facilitates proof of due execution. Section 127 of the Evidence Act raises the presumption of due execution, sealing, and delivery where a document is proven to have been signed and duly attested. It is immaterial that no impression of a seal appears on it. However, there are certain exceptions where the law requires that certain deeds or documents be attested to. In those cases, attestation is required as a matter of law and its absence to vitiate the deed or document. They include a deeds or document executed by illiterates. Where an illiterate executes a deed or document, or where is among those executing, his execution must be attested to by a magistrate, justice of the peace or notary public. See section 8 sub 1 Land Instrument Registration Law. Here the illiterate jurat is mandatory and attestation is also mandatory. B. A deed or document executed by a blind person. Where a blind person executes a deed or document, or where is among those executing, his execution must be attested to by a magistrate, justice of the peace, commissioner for oaths, or notary public. See Akimbadi and Olainka. C. Deeds or documents executed by a company or corporation or incorporated trustees. The execution of a deed by any of these bodies must be attested to by its clerk, secretary, director, or other permanent officer. For a company, it must be in the presence of a director and the secretary of the company. For incorporated trustees, in the presence of the secretary and a trustee or two trustees. See section 98 sub 1 PCL, section 163 Evidence Act 2011. D. Wills. Attestation by two or more witnesses is a mandatory requirement for the validity of a will. This is because Section 9 of the Wills Act 1837 provides inter alia that the execution of a will must be attested to by two or more witnesses in the presence of the testator, but that no form of attestation shall be necessary. See White and White. E. Power of attorney. A power of attorney also requires attestation, but the attestation can be by any independent person except if the donor is illiterate or blind. See section 150 Evidence Act 2011. In the case of a power of attorney executed outside the country for the purposes of conferring the power to execute a deed, it should be authenticated by a notary public, any court, judge, magistrate, consul, or representative of Nigeria. See Nubia and AG River State. It is necessary that independent persons attest to the execution of the deed. This facilitates the proof of due execution of the deed. Endorsement of governor's consent. Where consent of an authority is a statutory requirement before an alienation of land is done, the fact that the consent is obtained must be endorsed on the deed. Section 22 Land Use Act and Section 10 of the Land Instrument Registration Act provides that no instrument requiring the consent of the governor or any public officer for the validity thereof shall be registered unless such consent be endorsed thereon, or the registrar is otherwise satisfied that such consent has been given. The practice is to endorse at the very end of the deed words to this effect: I consent to this transaction, dated this dash day of dash 20 dash governor of dash state. Failure to make provisions for this in the deed will constitute a material omission unless there is other evidence that consent was in fact obtained at ADG and MBN Limited. Engrossment. This is the making of fair copies or counterpart of the original deed. It is not essential to the validity of a deed, but it is a way of ensuring that each of the parties have a counterpart of the original. Alterations and erasures. These are presumed to have been made before execution. Section 128 Sub 2 Evidence Act 2011. It is prudent to ensure that all alterations or erasure are clearly initialed by the parties to the deed at the time of execution. An alteration varies rights and liabilities of parties and may amount to a cancellation of such right or clause. OT and 1 Equi, 1993, Nigerian Weekly Law Report 3, Part 140, page 550 at 562. Franking. The name and address of the legal practitioner that prepared the deed must be endorsed on the document. The advantage of this practice is that it removes the document from the provisions of the Illiterate Protection Act, as a duly franked document is not invalidated by the absence of the Illiterate Jury Act. See Saka Barrymore and Mrs. Karimo, Edokpolo and Oe. In Eya and Kudus, the Court of Appeal sitting in Ibadan restated the position thus: by virtue of Section 5 of the Illiterate Protection Law, Cap 47, Laws of Ogun State of Nigeria 1948, the provisions of the law do not apply to any letter or other document written in the course of his business by or at the direction of any person admitted to practice and practicing as a legal practitioner in the High Court or the Supreme Court. In the instant case, Exhibit F being a document prepared by a legal practitioner was validly prepared and it need not have any illiterate juror. Thus, the juror therein was superfluous, although its inclusion was prudent. Date. The date of a deed is desirable but not mandatory in most transactions. A deed is valid even if it has no date or it has a false or impossible date. Jegede and Citicorp Nigeria Limited 2001 4 Nigerian Weekly Law Report Part 702 112. A deed is generally presumed to be made on the date of delivery. However, a deed of lease must be dated. Quick glance note is powered by Rooms and Luxury, your choice real estate agency in Lagos, Nigeria. Address is number 7 Tower Conic Close off Idemai Crescent, Igwefon, Lekki, Lagos, Nigeria. Tell WhatsApp 08142755425 09156911367 and send your emails to ronumsandluxury@gmail.com, Instagram Ronums and Luxury, Facebook Ronums and Luxury. You can call them for all your real estate questions. For sponsorship and advert placements, please contact 09125921620 or send an email to resistandpartners.chambers@gmail.com.